It's actually quite an exciting time to be a civil servant at the moment. I would tell you exactly what's going to happen on October 31st and beyond, except unfortunately I left my crystal ball back in London. But on data, as John said, we have negotiated provisions in the withdrawal agreement, Title 7, implementation period. This is what I did with my colleagues in DEXU. Provisions that preserve continuity of data flows. And in the case of no deal, of course, we are keeping, we're preparing for all outcomes. We're preparing for the possibility of no deal, including working with the Information Commission's Office to issue guidelines to businesses. So in any case, in civil service and DCMS, we're carrying on preparing for all outcomes. As John just raised, a question we often get is, does Brexit mean more margin for manoeuvre for the UK? Does this mean that we are going to seek to lower data protection standards going forward in the future? And the answer to that is unequivocally no. There will be no race to the bottom. That's not what Brexit means. We have a very long tradition in the UK of being a world leader in promoting data protection standards. We were one of the very first countries to sign the Convention 108 back in the 80s. And as John set out, we played a very active role in developing the GDPR. We achieved our negotiating objectives. We ensured that the regulation was proportionate while also protecting data protection rights. And indeed, we championed the GDPR and voted for it in Council along with the Law Enforcement Directive. So this is a long tradition that we're determined to uphold. And that's why we've brought forward very recently legislation that ensures that we will be uniquely aligned with the EU data acquis on Brexit. Currently, at the moment, our data protection legislation consists of two main instruments. There's naturally the GDPR, because as a member state, well, still as a member state, it is directly applicable to us, and the Data Protection Act, secondly, which implements the Law Enforcement Directive and provides for further specifications to the GDPR, including various provisions for the ICO and other provisions that complement the GDPR. Now, when we exit, whether it's after the implementation period or whether it's no deal, there would be a gap because the GDPR would no longer be directly applicable. So that's why we filled that gap with, firstly, the European Union Withdrawal Act, which sort of brings in EU law, including the GDPR, makes it domestic law. And secondly, our recent statutory instrument called the DPEC regulations. DPEC regulations, that's what we call them in the government. And what the DPEC regulations do is they amend the European Union Withdrawal Act so as to fix any deficiencies, which I'll get onto in a moment. And together, these form what we have very creatively called the UK GDPR. And this ensures that our data protection legislation functions correctly on exit, whether it's no deal exit or after an implementation period. So I mentioned deficiencies. Deficiencies are not about lowering standards, taking advantage of any margin for manoeuvre, because the UK GDPR maintains data subject rights, it maintains the data protection standards, it maintains the obligations, the responsibilities of controllers and processors that we see in the EU GDPR, in the EU acquis. What the DPEC regulations do is remedy things that simply would not work upon exit. So there's quite a lot of terminology in the GDPR which is EU specific, references to member states, references to EU bodies, references to union law. These naturally work while we're still a member state. They don't work upon exit. And so the DPEC regulation was all about fixing these references, changing them to UK, domestic law, Secretary of State of DCMS, etc. In particular, one of the things we amended was Article 51, and I know there were some queries that we had on this about whether we'd somehow remove the independence of the Information Commissioner's Office by altering that. And I confirm absolutely we did not. This was about, again, removing a phrase that referred to member states. And as you can see from the copy of the UK GDPR, which was provided in the conference pack, we have perfectly preserved Article 52, which contains the requirement for the ICO to act in complete independence. And this is also supported by the DPA 2018 and other statutory legislation. So the point of the DPET regulations of the UK GDPR was to maintain continuity, to maintain data subject rights, the level of protection, and also put us in the best possible position to achieve an adequacy decision. John mentioned international transfers, and I also mentioned the references to EU bodies that the DPIT regulations set out to fix. This is because the GDPR confers various legislative functions or quasi-legislative functions on the European Commission. Upon Brexit, these will transfer to our Secretary of State, and it brings me to the point about how we engage with the wider world, because of course these powers, these functions, include the power to make adequacy decisions. And as stated in the political declaration that's attached to the withdrawal agreement, as an independent country, the UK will, of course, upon exit, have its own independent international transfers regime, or ITR as we call it. Now, while we're still a member state, of course, we won't be making our own adequacy decisions. Same happens in the case of deal in the implementation period, because we will still be bound by EU law. But we're currently in DCMS establishing our capability.
DCMS, Department of Digital Culture,
yes.
Media and Sport.
Thank you.
Yes. Responsible for data protection.
Yes, so in our department we're working on establishing our future capability to make such decisions. We're setting up brand new teams with a view to being able to make these arrangements. And I think it should go without saying that we have no intention of lowering our standards again, including when it comes to transfers of data across borders. And also, indeed, because of our alignment with the EU, the UK does not intend to impose any additional requirements on transfers to the EU or the EEA. The DPEC statutory instrument actually transitionally recognises the EU, the EEA, Gibraltar, etc., as if they'd already received an affirmative adequacy decision from our Secretary of State. And the same is also true for existing adequacy decisions, any ones that the Commission have made before exit day, including Switzerland. These will, of course, be kept under review as the decisions by the European Commission are. We've also been working with the existing adequacy decisions, including Switzerland, to maintain existing data flows from them to the UK. And so far we've had 12 who have informed us of their intention to maintain uninterrupted, unrestricted flows. And these decisions or these statements are set out in a list that's managed by the ICO on their website. As part of doing this, as part of working with the existing adequacy decisions, we provided quite a bit of detail on our regime, on our alignment with the EU. We've set out essentially how, with the UK GDPR, we're preserving all the elements that are recognised in the European Data Protection Board's adequacy referential, which sets out guidelines to the Commission about what they should be looking for when making an adequacy decision, including obviously the lawful basis of the GDPR, principles, data subject rights, obligations. We also set out the strong track record of our Information Commissioner's Office and their complete independence. And this information, well, we stand ready to provide it also to the European Commission when they're ready to begin the adequacy discussions to help them with their assessment. And ideally we'll be able to use this and our UK GDPR, our statutory instrument, to show that we not only meet the standard of essential equivalence, but we actually exceed it.